Thank you ever so much. You may be seated. Well, Council, you have an hour stretch. From now on, let's try and do it within the time.
Thank you, Justice. Justice, I'm going to move on from to a new topic. I have dealt with the issues relating to the claimant's claim for constitutional damages. And I just want now to deal with matters relating to the quantum that they seek. Justice, in terms of the statements of claim, of the claimants represented by Hatter Spears, they claim 1,500,000.
I know that last word, you've always called it for all these months, Spears. Spears. It is Spears.
Spears.
Thank you.
Thank you for the correction, Justice. And
Spears mean more closer to your Amari.
And the same amount of 1.5 million is sought by the claimants, represented by Section 27. And from the evidence that or the submissions which has been made by Section 27, they sought to rely on the calculations made by Mr. Whittaker, who was called as an expert, the actuary, who made the calculations of what would have been paid to the mental health care users had they not died. Justice, what we submit is that his evidence was not of assistance to these proceedings. What we have submitted in our heads, we say that he was engaged
in an exercise in futility.
In an exercise in futility.
You see, I remember your words.
For the simple reasons that Mr. Whittaker was not appraised of what the claimants were seeking in terms of the amounts and in respect of what claim. So the exercise really was addressing issues not relevant to the determination of the claim sought by the claimants. And I do not want to deliberate on this aspect any longer. The Justice has already raised concerns about the report. All that I just want to submit is that this tribunal should reject his evidence in its entirety as of no value to these proceedings. And I say so on the principles laid in the case of PricewaterhouseCoopers Incorporated and others, and the National Potato Cooperative Limited, IMF Australia, National Potato Cooperative Limited, and another, where the court held at paragraph 99 that or set out the legal principles and tools to assess credibility and reliability.
Yeah, but let's just before you read the passage, let's just get something clear. We're not attacking the competence of Mr. Whittaker, are we?
No.
Certainly not. And we're not attacking the fact that on the mandate given to him, he executed the mandate. What's debatable is whether, in fact, the calculations were useful to determine constitutional damages.
Indeed so.
So we must just get that clear. It's a professional person who's come and done his work properly.
Indeed.
So I don't want any aspersions on the integrity and the quality of the work. But the question is it useful to the arbitrator in determining
like
quantum of damages?
Yes, like he actually made it clear, even during cross-examination, that what he testified on was in relation to the brief that was given to him. And the brief was nothing else than to calculate what would have been paid to the mental health care users.
Sure.
The submission which I'm making is that that report in its entirety, together with his evidence, does not assist these proceedings.
Yes. I'm alive to PricewaterhouseCoopers and expert testimony. So you don't have to read the passage to me.
Thank you. Yes. So that...
But you're not inviting me to make a credibility finding, certainly not.
Well, Justice, the submission...
You're inviting me to find that it is not relevant to...
That's correct.
...to the computation.
That's correct.
Very well.
Yes. And that is to illustrate the point that so much argument was made by the claimants when they sought to rely on the two cases which granted constitutional damages. And in that regard, they relied on the cases of Kate as well as Moderate Clap. But what we know about those cases is that they are distinct to the facts in issue, in a sense that those two cases dealt with quantifiable or determinable amounts, which the parties sought assistance from. And it was the damages were granted on the basis that there was nothing under common law which could come to their assistance. And it was on that basis that the courts then reshaped or broadened the issue relating to appropriate relief.
A Moderate Clap had nothing to do with the common law.
Yes.
Just unlawful occupation of premises.
Yes.
So unlawful occupiers, and the state never intervened to protect his right to property.
So the relief was given pursuant to the powers given to the court in terms of Section 38 of the Constitution, which allows the court to make any appropriate relief.
You couldn't have filed a claim under Moderate Clap under the common law.
Indeed. Yes. Well, like the point which I'm trying to say is that those cases are not of assistance to the claimants because the facts are different.
No, but yeah, the facts are different, but the principle of law, I think, remains quite important, is it not? Section 38 permits a court to grant appropriate relief.
Indeed.
And you don't need to get the common law behind the mountain.
Yes.
In order to be able to do that. I think that's
yes.
the takeaway from those cases.
Yeah.
Yeah.
Okay.
In other words, it doesn't mean if there's no common law, courts have no power to grant relief.
Mm. Well, like the most important aspect in those cases is that, like, as I've submitted, that they were decided on quantifiable
yes.
amounts because they have proved loss.
But you can't. Are you arguing that if the loss is not quantifiable, Section 38 is not available to claimants?
Well, I'm making the submission in relation to what was sought to be relied on, the quantification of those damages through the use of an actuarial expert. Then, Justice, if I can move on to the other aspect of my submissions in relation to claimants represented by the legal aid.
Well, before you move away, what do you say about that quantum? Why is it inappropriate? Assuming constitutional damages are within the gift of this tribunal, what amount is appropriate? Are you going to debate that or not?
Justice.
I know what your argument is.
Yes.
But you know, quite often in the courts, assuming yes. your submission is not good, what amount should I grant?
Yes. Justice, in the unlikely event of the tribunal finding that indeed there is a claim.
Unlikely event. That's what pilots say in an aeroplane. I don't know here, but yes, you go ahead.
Yes. What I submit is that this tribunal should follow the principles which have been laid out by Justice Mokgoro in the Dikoko case at paragraph 69. I've addressed that aspect, and it's
you know, I didn't want to interrupt you. In Dikoko, the one part of the court took the view that there should be an amend something, which is an apology. Another part of the court, I think incidentally the majority, held that whilst apology is wonderful, there should be place also for compensation. I don't want to debate that because there's a split court. I don't want to get back to Dikoko. And I wrote in the judgment for, if I remember well, the majority. But that is neither here nor there. I want to know from you what amount, and I agree with the sentiment, I agree with Justice Mokgoro, money does not assuage, does not heal everything.
Yes.
It's certainly not.
Yes.
In our own languages, you know how often in African languages, there are idiomatic expressions about money won't wake up the deceased, money won't wipe our tears, money won't. So it is quite well known in certain cultures, in most cultures. I won't say all, but that money is not a balm for every wound. So I take the point, and I think it's a good point, and I agree with my learned sister and colleague, Justice Mokgoro. Courts, nonetheless, are called upon to make redress. The Constitution requires courts to give appropriate relief, and I have the obligation to do so. Assuming I hold the view that I should grant constitutional damages. In what amount? We know what the claimant says.
Yes.
We know the state says, no, the relief should not be granted. If I do hold so, you're entitled to make submissions on how much it should be.
Justice, what we submit is that there should not be any amount in that regard, taking into account, first, what Justice Mohoro has said, and secondly, in light of the outcome of the common law damages which has been settled between the parties. So
you have no submissions on the quantum of constitutional damages?
Indeed so. And then other than that, as is a known principle, the ultimate decision will lie in the discretion of you, the arbitrator.
Yes. Very well, you may proceed.
Yes. Justice, I wanted to start off with the claimants represented by...
Before you walk away from that point, you know, award of compensation arising from very egregious conduct, if not commensurate with the facts and circumstances, doesn't it sometimes lead to even further insult over the injury? Is that a relevant consideration? Should a court be carefully weighing? Is this a case of a slap on the wrist, or is it a case where I'm required to keep in mind that it ought not to be an award that will insult the aggrieved and the bereaved?
Well, Justice, in making the award for damages, any amount so awarded should be fair for both sides. And my submission is that, taking into account the two aspects which I have related to, the quantum in relation to general damages, as well as the principles laid out in the Dikoko case, that should achieve the purpose, and it should be fair on the part of the claimants, and at the same time on the part of the respondents.
Let me tell you a little story of me as a young man. You know, when you get older, you have a lot of stories to tell. You know, you'll discover this. We had a guy who was a bully who lived in my neighborhood. He would beat you up. You cry, and he walks up to you and says, I apologize. Ntshwarele, man, I apologize. He says it for the third time, and you don't say, I accept your apology. He beats you up again.
Yes.
In other words, the apology becomes everything for him.
Yes.
And wants the apology to be sufficient, but above all, to compel you to accept the apology, however painful you might be feeling. So it may be that apologies are very important in life, but certainly not something you can impose on others.
Yes.
I've apologized. Why don't you accept my apology? So shouldn't I make allowance for that also?
Well, like Justice is indeed correct that that has to be taken into account. But if we have regard to the present case, and the example that Justice has given just reminded me of the decision in Kate, where the court said this problem has been endemic, and which was the reason why such a claim was granted. In the present case, it is indeed regrettable and unfortunate, but like this is one incident which had occurred. It's not a case where it's a repetitive breaches on the part of the government. So on that basis, Justice, I want to submit that in making that consideration, the justice should not equate the apologies given in these proceedings the same way as the apology given by the bully.
Yeah, well, I understand. You've made your point, and I've heard it. You can proceed with your next point.
Thank you. The claimants in this instance, they are in two categories. The one category is the survivors, and the survivors being defined as those mental health care users who survived the Marathon Project. And on the other hand, there's a claim by the families of those mental health care users. On their behalf, a statement of claim has been prepared in which, at paragraph 4, legal aid, yeah, sorry. I beg your pardon, Justice, I pulled the wrong document. It is a statement of claim by Hatter's Peace.
It should be LSSA statement of claim, surely, that we're looking at now.
Yes. What the claimants seek is the following. Still on paragraph 4 of the statement of claim of the survivors, insofar as compensation for the mental health care users and their families, our clients seek 4.1, an amount of 1 million rands in respect of general damages for shock, pain, and suffering for each of the said mental health care users as identified in the Mental Health Care Act. And then 4.2 reads that in respect of the family of each mental health care user, they claim an amount of 5,000 specific damages, 50,000 future medical expenses, 1,000 in respect of costs incurred to locate the mental health care users. And then at 4.2.5, an amount of 1 million rands for constitutional damages. And the point which I'm trying to highlight in this statement is that what appears is that constitutional damages are being sought on behalf of the family members of the mental health care users, whereas the mental health care users themselves, they only claim for general damages for shock, pain, and suffering. That being said, Justice, I don't want to dwell much on the legal principles for the determination of what is fair and reasonable compensation in relation to the claims. If I can just deal with the amount of 1 million rands in respect of general damages for shock and pain. In my case, Justice, I deal with these principles at page 11. At paragraph 20, I submit that the primary issues for determination by the arbitrator are restricted to an assessment of what would constitute equitable redress and the quantum of compensation to be awarded to the claimants. And paragraph 21 I'm going to proceed to paragraph 23 at page 12, where I submit that an award of general damages seeks to compensate the plaintiff for loss suffered in respect of the plaintiff's personality interests. It seeks, therefore, to compensate the plaintiff for pain and suffering occasioned by the loss-causing event, physical and other trauma and loss of amenities of life. Justice, right at the beginning, I did indicate that the state does not dispute the contents of the Ombuds's report in relation to the merits. So I will not debate their entitlement to the relief sought. But what I seek to do is to assist you, Justice, to consider previous cases where awards have been made so that you will be able to arrive at a fair amount.
Yes, I'm grateful for that collection of cases. They are helpful. Thank you very much. I want you to point me to one that points to the same intensity and the same level of egregiousness in a collective endeavor by the state. I looked at them. Can you find any? Which one do you say would be the closest?
Justice, I want to refer to one or two cases which deals with death, where someone has died, and consider what it is that the court had arrived at as a reasonable amount for compensation. And I say so, regard being had to the fact that in this category of the claimants, the issue of death does not arise. Firstly, I deal with the case of Majid versus Santim, where the plaintiff claimed for damages for emotional or nervous shock sustained as a result of her coming upon the body of her 9-year-old shortly after the accident. And all that I want to submit is that the circumstances were so dire that the plaintiff suffered major depressive disorder subsequent to the death of her son. It was recorded that the plaintiff became hysterical and collapsed at the roadside with shock causing a period of psychogenic amnesia to set in, followed by ongoing major depression disorder of moderate severity. This being a serious psychiatric illness, still evident 6 years after the accident. And in this case, the plaintiff called 2 experts to demonstrate the nature and the extent of trauma.
Yes, you can accept that I've read the
Yes.
your heads and the descriptions there.
Yes.
So we have to move a little faster. Accept.
Yes. And
I'm familiar with the circumstances of the cases you cite. Yes.
Then, like in that regard, the court awarded an amount of 35,000 rands.
Yes. Nearly 10 years ago.
Yes.
Okay.
And sorry, just give me a small paper.
Kreisinger.
Justice, I just want to make reference to the current value of the monetary award.
Yes, certainly.
That has been given, so that like it could be of relevance. If I can just be given a minute.
Oh, yes.
Justice, my instructing attorneys are assisting me in this regard. The amount in Majid case is in current value in terms of the quantum year book by Robert Koch, 2018. The current value is 115.
Yes. Money doubles every 5 years. That's correct, yeah.
Yes.
That's what it would be.
Yes. And then the other case is Kreisinger.
It's also 200,000 rand
Yes.
10 years ago.
Yes.
Right.
And the point which like I want to make is that the circumstances where all of them involved the death of people, and therefore any amount which will be reasonable cannot be the equivalent of what the court had granted in those judgments, or even be higher. So in the exercise of your discretion, Justice, I submit that a reasonable amount should be in the region of between 80,000 and 100,000 rands.
That is in relation to general damages, right?
Indeed. So those are my submissions. The point which I'm trying to emphasize is that in all the cases that I have made reference, people have died, and the level of trauma and shock will obviously be different to cases where death did not ensue.
Yes. In paragraph 40, you suggest 80,000 rand.
Yes. Justice, you will have noted at paragraph 41 of the heads, I have quite extensively quoted the judgment of Mabuse J in the Pretoria High Court, the North Gauteng High Court, in the case of NJJ Webb versus Road Accident Fund, where the court dealt with considerations that the court should take into account in the determination of an amount of damages. I take it that the justice has read the heads, but the point which I want to emphasize is that on page 21, I submit that the court said, this means that in general, a court should not merely out of sympathy with the plaintiff award a huge amount of money at the expense of the defendant. And
do you think giving R1 million to a claimant in a case of these circumstances is burdening the defendant?
I submit so in light of what the respondents has been put through in order to deal with these issues emanating from the Marathon Project. I should indicate that this arbitration on its own comes at a huge cost, and for good reasons. For good reasons, and what MEC Chrissy testified during cross-examination about the expense which were spent in these proceedings. She clearly indicated that the most important thing is to respond humanely to the families, and therefore it is quite important. The point which I'm trying to say is that regard being had to the costs which the respondents incur in order to address the difficulties that the families have went through should be taken into account.
Well, who started the difficulties? How were they caused? Why are we here? Let's just be careful. You remember the story of the bully?
Yes.
Look what I've done for you after beating you up. I've said sorry. So shut up. You know, let's just be careful. I mean, we're here precisely because there was this egregious, horrendous devastation of human life. So we can't now say, look how good we were. Look how we've set up. It's a relevant consideration,
yes,
and I'll keep it in mind. But we must, yes, just be careful.
Yes.
Talking about MEC Chrissy, her evidence also disclosed amazing levels of waste, isn't it? Amazing levels of disregard for public funds. 6.8 billion of unaccounted expenditure. I mean, expenditure on consultants. 1.6 of that was referred to the ICU. We're still waiting for outcomes. So you take that and you look at it and see the readiness and the level of wastage on the one side. And I'm open to be persuaded that R1 million to a claimant is wasteful, is burdensome on the state. And if so, tell me why it is. When there's such high levels of wastage on public money that ought to be protected, as against very, very poor people who have gone through immense trauma. Why is R1 million too much?
Well, Justice, issues relating to wasteful expenditure, it is indeed correct, evidence was led in regard to that. But what has to be considered is what measures are being taken to deal with those aspects. And what has come out from the evidence was that investigations are being conducted pursuant to those expenditure. And those matters fall within the laws regulating the use or the use of funds in government. So if we have regard to that, and the purpose sought to be achieved, then I'll submit that the tribunal should not overburden the respondents.
If we just cut the cost of the consultants alone, there might be enough money to be able to find appropriate relief. Let's just be a little sensitive about this.
Yes.
Complain about being burdened. In these circumstances, it's a bit rich. Anyway, yes. I'm listening to your further submissions.
Thank you. And Justice, the other claim which has been advanced on behalf of the family members of the mental health care users is in respect of constitutional damages, which is set at the amount of 1 million rands. Justice, I wouldn't want to repeat the same submissions which I have made in this regard.
The point that you may have is that it may lead to double dipping. You may have, and I think any arbitrator would have to keep that in mind.
Yes.
Whether the claimant is entitled to $1 million in general damages and $1 million in constitutional damages.
That's correct. Yes.
Yeah. That is a legitimate complaint to make and say, well, this might amount to dual compensation. Yes. But quite another to say they should get nothing.
Yes. Those are my submissions.
How much in general damages do you think the survivors should be getting? Because as I understand, you have no agreement with the Law Society. In your view, how much should they be getting on general damages, on your argument?
Justice, in respect of both the mental health care users and the families, I submit that an amount of 200,000 should fairly compensate the hurt that they had endured. And without wanting to be seen to be imposing on you, Justice, I'll recommend that that should be the amount that should be made. And from what we have debated earlier on, and in regard to what you have just said, Justice, let's avoid double dipping in relation to the claim for constitutional damages. It should be sufficient for general damages and other measures which the government has agreed to put in place as a form of appropriate and effective remedy. The remedy is not only in monetary terms. There are other issues which the Justice...
Shall we go to those quickly? Shall we talk about them? What do you think they should be? You've heard the submissions from your colleagues.
Yes. The issues relate to counseling.
Who should do the counseling?
The respondents in this regard. The government should offer that to the...
And how would the claimants access counseling by the respondent? What award should I make?
Justice, if an arrangement can be made with the department to put in place, the award should direct the department to put a mechanism in place for your approval. And the other aspect relates to a place of memorial, and which the state.
And you don't contest the suggested frequency of the counseling and so on,
Well,
to be found in other heads,
well,
the number of family members who may receive counseling.
Justice, I will not be able to commit to that from my submission that the department should be able to formulate a model with your approval, then like that can form the basis upon which such service can be used. Yes, yes. I've just been assisted, Justice, that on that aspect of counseling, going back to the statement of claim by Section 27, paragraph 10.1, where the suggestion is that an individual and or family assessment by a psychologist to determine the extent and the nature of counseling and support services required by each claimant and their family. So like those are the matters which will be dealt with in order to cater for that.
Okay.
And the other aspect that like I have mentioned is with regard to the place of memorabilia, which was in fact proposed by the Ombud in his recommendations.
What order should I make?
That in consultation, that the department in consultation with the claimants should agree on the place or the site where it is supposed to be put.
Place, site, and I suppose the nature or character of the memorial.
Indeed.
Yes.
Justice, the other aspect, as a way of demonstrating the government's willingness to correct itself in response to what had occurred, I submit that a declaration of rights and corrective measures can be made, and I say so in regard to those who have survived the Marathon Project, that proper measures should be taken to ensure that they receive proper care and treatment in order to avoid what had actually happened. And the other aspect can be a directive to the department itself in the form of mandamus. And I must say that this is an aspect that the government has already undertaken in pursuant to what the Ombud has recommended at recommendation number 14, which deals with the review of legislation which is relevant for the care of mental health care users. The government has already embarked on that process as another way of ensuring that the issues are dealt with. Yes. And the other aspect, Justice, relates to the concern which has been raised during the testimony that what assurance do the mental health care users have that history will not repeat itself? And in this regard, what has been suggested and as recommended by the Health Ombudsman was that should there be any reason which requires the mental health care users to be moved, such a decision has to be taken in conjunction with the National Minister of Health, just to ensure that the process is overseen properly and implemented in accordance with the law, avoiding prejudice and suffering to the mental health care users. So those are the factors that
and in consultation with the family members of the persons who are to be moved, isn't it?
Indeed, indeed, indeed. And that will be in line with what has already been arranged with regard to the position made available to a member of the family committee in the review board.
Yes.
Because in
but the Mental Health Care Act regulates that in any event, isn't it?
Indeed.
There's a definition of mental health care user, which includes the family, and it prescribes consultation, which is mandatory, isn't it?
Yes, but like the point which I'm trying to say is that apart from those statutory requirements, there is a special, there is a position given to a member of the family committee to sit in the board over and above the required consultations. And that person is there to generally look at the interests of the mental health care users, not only during their transfer, but during the continued period of them being cared for. Anything else?
What about the written apology published to all and sundry? In writing, not just here before us, within a specified number of days after the award?
Justice, I understand that there is, in fact, a pledge that the Department of Health has prepared as a form of acknowledging what had occurred and tendering its apology to everyone who is affected.
Can I have a copy of the pledge and see whether I would want to include that in the award in those terms?
Certainly, Justice, if we can be allowed to make it available. Oh, yes. Thank you.
Yes, it can be copied and made available to everybody and to me. I would like to look at its terms.
Indeed, we do have a copy of that pledge.
We need to memorialize the apology.
Yes.
As we memorialize in stone and in brick and in concrete, we need to memorialize in words so that we can be able to show posterity and say, look, we messed up once, and look, the state apologized.
Indeed, so Justice. A copy will be made available to all the parties and will make it available to you.
Yes, thank you.
Yes.
The other element of the award, if I were to find that there are indeed constitutional damages that ought to be awarded and are awarded in a particular amount, let's for argument's sake, as the head suggests, 1.5 million and 500,000 is donated by the claimants into a fund. And I'm inclined to go along with that particular submission. Who should manage the fund and who should oversee the fund?
Well, Justice, the issues relating to expenditure on the part of government, as I've said, is regulated by the by the laws of the country. And I'll be reluctant to agree that there should be a special fund created for the mental health care users. The government has taken up its responsibility, and budgets will have to be made in accordance with processes of government where there will be accountability. And to want to make certain funds available outside that scheme might create problems. So my submission is that the government should be left with that task of ensuring that proper budget in terms of the law is being made available.
So you're really saying if the mental health care claimants want to set up a fund and use it the way they want to, that's their business?
If an award is being made in their favor, certainly it is not for the government to dictate how and for what should they make use of the amount of damages awarded to them.
I get the submission.
Those are our submissions, Justice.
Costs.
Justice, it appears that the costs will have to follow the ordinary rules. Costs should follow the event.
A wise submission indeed. Costs will follow the event. Very well, thank you. Council, thank you. And I would like to thank you for raising the issues you have. And indeed, some of the submissions will be used in these considerations. And thank you for the heads of argument, which are detailed and well worked and much appreciated. And you've raised a matter which I will have to address in the award about the niggling relationship between the common law and the Constitution. So I just want to be grateful to you and your team for the work you've done.
Thank you, Justice.
Yes. We've come to the time for replies. It's 1 o'clock. I would like to be done by 2 o'clock. The outer limit 2:30. And people can eat for as long as they want to thereafter. So I'm inclined to go ahead. I don't know why the replies should not be contained within the hour, or the outer limit 1.5 hours. Is it okay that I proceed, Council? I would like to, for reasons that you all are aware of, but also in the interest of finality.
Thank you, Justice. We would have no objection. We will try to adhere to the times.
To push
given.
to the end and adhere to some time. We have basically 1.5 hours in which to do, and a replique is a replique. It means you go to those issues raised in the argument by your colleague, not to repeat one's argument unduly. That's what it is there for. So it's a retort rather than fresh argument. Council?
Thank you, Justice. Justice, before I begin with the reply, when I ended my submissions yesterday, I owed you a reference to the record in relation to the SAP's investigations of a range of potential criminal charges, and that's to be found in file 3 at page 1171.
Thank you.
And the second thing is we spoke about crafting the relief in a way that would assist the arbitrator in preparing the award. And I request that we are permitted to circulate and submit to you a draft of the terms of our relief in order to assist with crafting the remedy.
Oh, yes. You're entitled to do that, to propose a draft award.
Thank you, Justice. We aren't able to do so today, but we will do so next week.
You have to serve it on your colleagues first,
Yes.
all of them, and they're entitled, intend to propose alternative drafts, as always. So once they get your draft award and circulate it to them first, and then they're entitled to propose before the time an award to me, and we can have a look at that.
Thank you, Justice. Then to turn to my reply, I have to say that I can't resist the temptation to refer to a quotation from Shakespeare that comes to mind when I was hearing the argument on behalf of the state. And it's from Hamlet. And it's the quotation in which Hamlet says, "There are more things in heaven and earth, Horatio, than are dreamt of in your philosophy." And I think that the arguments that have been advanced by the state in relation to the common law damages and the need to, and I'll argue in a moment, unsuit us in relation to constitutional damages, that quote is quite pertinent. Our statement of claim is really where we begin. The terms of reference and of course, the statement of claim. The terms of reference we've been through, and it's clear that it involves an award of compensation to affected families. The statement of claim in Claim C refers to a claim for constitutional damages arising from not just the deaths, but the circumstances of the deaths. And that claim is made by each of the affected families. And that's important because the precise reason that it was necessary to formulate Claim C is because there is nothing in the common law that comes to our assistance for the deaths that have occurred under these circumstances. And there's also nothing in the common law that can assist the families in relation to the circumstances of the deaths. In other words, the violations of the rights. What is startling is that...
That friend was trying to push you into that very corner and say that, he didn't say in so many words, death has no consequences under the common law. Yours is to cry and express your shock and trauma, and that's all that the law can help you on. But in effect, and it's not far from the truth, the common law did not recognize death, did not reward death, or compensate for death only. So that's really the essence of that argument. You have not claimed merely for dying. You have claimed for the shock as a result of the death of another.
And we spent much time in our written submissions and in our oral submissions explaining why the common law is deficient, which is what necessitated our Claim C. And so we find it startling that the state persists and seeks to argue that the breaches of the rights of the mental health care users are not relevant. They ask you to close your eyes to it, that the families are not affected, that they've suffered from some trauma, but that's it, as you say, Justice. And that the common law in relation to trauma suffices. Now, our submission is that even the common law in relation to trauma is deficient. There is no precedent in our common law that comes close to the facts that pertain in the matter before us. And we're not talking about one death. We're not talking about some disparate deaths that take place unconnected with one another. We're talking about an atrocity. Reliance on the common law alone would not bring an appropriate remedy and relief to the families. The incredible argument by the state I'm afraid to say, undermines a lot that has been done in this arbitration thus far. It's treating the families as if they were bystanders. They're not claimants of rights in their own regard. They were bystanders. But as we said in our submissions, they were much more than that. The families were much more than that. Over many months, they endured a parallel process of suffering and anxiety, one that tracked that of their relatives, now deceased, whose interests they were trying to protect. The tenor of the argument of the state is that we have paid for the arbitration process, and now we can pat the families on their head and send them off. In other words, the state has not met our argument regarding the insufficiency of the common law, has not met our arguments in relation to the extraordinary circumstances of the case, the egregiousness and wanton nature of the violations, the vindicatory aspect of constitutional damages, by an award that we submit is intended to be signal. It's intended to be an award that affirms the core values of the Constitution, the social pact that we've all agreed upon and that the Constitution represents.
Well, the argument seems to say you are locked into the common law. You may not formulate claims or seek relief outside the four corners of the common law. Is that an accurate representation of our constitutional arrangements?
Well, Justice, there's certainly no case that I'm aware of in which that has been held, that one has to stick to the common law and not go beyond it. And if that were so, it would make the ability to vindicate rights directly, to enforce rights directly through Section 38, it would hinder the ability to do so. It will be, in fact, more than hinder, it would debilitate. In relation to the Mental Health Review Board, I'd like to just point out, Justice, that Section 20 of the Mental Health Care Act, 17 of 2002, concerns the composition of the Mental Health Review Board, and it requires that it must include a member of the community concerned. So we're pleased to hear that the department has now chosen to include a community member, but that is in any event the department's statutory obligation. Justice, those are my submissions in reply. I did indicate at the end of my submissions yesterday, and I feel even more strongly about it now in the light of the argument we've just heard from the state, that it is important to remember, and it's important for all of us, it's important for the families, and we submit it's important for you, Justice, to remember who are the people and what is the humanity behind the names, the people who have died in the process and that are being represented by Section 27 in these proceedings. It won't take an undue amount of time. As I recall, Justice, you did indicate that I would be able to do so.
Please proceed. I think the circumstances of this proceedings, that is not unreasonable.
Thank you, Justice. I begin with the clients who testified, and there were 17 of them, and then I will turn to all of the other deceased, and all of the information is in the affidavits, in the record, and the references to the record are in Annexure A. And I begin with Billy Mabwe.
What you are reading, I'm not going to have to hurriedly write down. You're going to give us a list of what you're reading, is it?
Justice, I'm not sure whether there are extra copies, but I'm certainly...
Not immediately, but I'm certainly...
It does not require you to take any notes.
Yeah, very well.
Billy Mabwe's father is Reverend Mabwe. He described Billy as always jolly when he was at Life Esidimeni. When Reverend went to visit Billy at Bophelong and took him some food, Billy was so hungry that he licked the chip packet clean. Daniel Josiah was a beloved brother. He liked it when his sister Wilhelmina spoke to him, even though he couldn't answer her. Soli Mashego was a beloved brother. He carried his sister Pumzile on his back to school when she was young. Freddie Collins liked sweets. He was a husband and a father. Masweet Kozwale was a beloved daughter and a niece. She stopped talking when she was transferred to Takalani. Virginia Machpela was a beloved mother and sister. When Virginia had to be admitted to Life Esidimeni, her daughter, Shanice, lived with Virginia's sister, Christine. Her death caused heartbreak to Shanice, who passed away in October 2017, just at the beginning of the arbitration. Sophia Mulefe was a beloved daughter and sister. Sophia overdosed on her medication. Vuyo Kondwane was a loved son and brother with a broad smile. He liked meat. Lucas Mokwerane described his brother Christopher as a piece of me. Lucas showed the arbitrator a picture of Christopher at his son's wedding. Christopher died after he fell in the bathroom in the middle of the night. Motofela Lerwabe was the youngest brother of Lesiba Lerwabe. After a long search, he was found at Cullinan with a broken ankle. Joseph Gumedi was Ntombi Futhi Ladla's older brother. He enjoyed spending Christmas and New Year with his family. When Joseph's body was found, it was riddled with worms. Christopher Makoba was a loved younger brother. He died at Precious Angels in July 2016. When his family went to collect his body, the undertaker had left it at the door for collection. Charity Ratsoso was a happy member of the family. His sister could not find him after the move, and after a long search was told that he had died months earlier. His family collected his decomposed body. Deborah Petla was a beloved daughter of Maria. Her post-mortem report found that there was plastic and brown paper in her stomach. Maureen Kunjwa was a beloved sister. She enjoyed the birthday parties her family would arrange for her. She wasted away at Takalani. The arbitrator saw pictures of her. Sizwe Tlatswayo was always happy. He liked singing and dancing. Sizwe would have turned 30 during the arbitration. Resibe Rahab Magena was a proud mother of 3. She took pride in her appearance and liked to dress up. When her son visited her at Takalani, he could not recognize her because she had lost so much of weight. She passed away at the age of 57. Felicity Adams was the mother of Gabriel Adams. Felicity enjoyed spending Christmas and Easter with her son and ex-husband. Before she died, she was moved between several facilities. Diederik Johannes Botha insisted on changing his nickname from Dickie to Johan when he was younger. He died at Sepong. Sapati Janet Pilani was the mother of Edith Pilani. Her favorite drink was tab when they visited at Life Esidimeni. She became blind at Precious Angels. Joy Simamane was the beloved and outspoken sister of Jacob Simamane. Johannes Jacobus Janse van Rensburg was the father of Joanne. He loved home-cooked pap and beef stew. Joanne was informed 15 days after Johannes's death. Nicholas Jamnik was the beloved brother of Mariana Jamnik Schmidt. He loved to read the newspaper. Johanna Claudi liked chicken licken, which her sister Sarah would always bring to her when she visited. After she was moved to Takalani home, she has been recorded as a suspected case of typhoid. However, her death is recorded as being due to natural causes. Christina Lale was the beloved aunt of Sophie Huetsamang Maklatsi. Christina was found at CCRC where she died. Charles Stewart was a huge source of support to his sister, Yvonne Mohammed. He was very proud of his 2014 award for the world's best male care user, mental health care user, for good behavior and loving care at Life Esidimeni. Siyabulela Roger Msimanga was the son of Lindiwe Portia Msimanga. He died of pulmonary tuberculosis and septicemia after being moved to Shama House. He was only 33. Matsabani John Mahloko was a beloved brother of Judah and the uncle of Peter Mahloko. After he was moved to Moseko home, he slept in a room with 2 beds and 5 other users. Peter Mvundla was a loved family member. He liked fruit, Coca-Cola, bread, and cigarettes. He died after being moved to Moseko home. Julian Peterson could not walk or speak. His family was distraught to find him disoriented, confused, and unkempt at Precious Angels. He could no longer sit up straight, and the staff tied him to his wheelchair. Jeremiah Modise enjoyed birthday parties. His family found his decomposed body in a hospital mortuary. Busisiwe Shabalala could not talk, but she would laugh with her family. She died dirty at CCRC. Beki Sitole was a beloved brother. He died at Siabadinga. His body was bandaged and bruised. His family buried him without knowing what happened to him. Matlakala Elizabeth Motswahe was the beloved mother of Maud. She had been transferred twice and died after the transfer to Precious Angels. Banika Mokaneng was a beloved cousin. She couldn't talk, but communicated with her eyes and gestures. She smiled a lot and loved holding children. Banika indicated to her sister that she had been raped while at Takalani. She died a few months later at Takalani. Julia Tsawe was the mother of Rosie Chabalala. Julia enjoyed the fruit that Rosie would take her. Julia was moved to Moseko home, then to CCRC, then to Precious Angels, and then to Kalafong Hospital, where she died. Terence Chaba was the beloved nephew of Susan Poshoko. He was moved to Precious Angels. Susan learned of Terence's death when they were called to a meeting at Pretoria West Hospital, and Terence was referred to as the late Terence Chaba. He was 28 years old. Pio Sibosiso Mtombeni was the brother of Stella Mofokeng. Sibosiso was deaf, but all his siblings communicated with him in sign language. He was moved to Bopelong, where no one could use sign language. Emily Mtembu was the sister of Tami Mtembu. She would not stop screaming when her family visited her at Anchor. She ate a 6-pack of yogurt in one sitting. Cindy van Rooyen was a beloved aunt and a sister of Vaughan van Rooyen. She died after her move to Takalani. Mamesi Sina Mosalo was the mother of Vinolia Mosalo. She loved doing beadwork. She was moved to Tsapong with only a night dress. Tembisile Lillian Dlamini was Vuzumuzi's Ladla's sister. She was close to all her siblings. Her brother saw her body with blood in the nose and mouth. Joseph Golden was the stepson of Winnie Golden. The family could not find Joseph after he was moved. They eventually found Joseph at Kalafong. By the time the family arrived, Joseph had died of hypoglycemia. Jabulani Mnisi was the beloved son of Yami Miriam Mnisi. Jabulani was moved without his mother being informed. He died at Tsapong without having seen his family. Caswell Mosiani was the beloved son of Yvonne Mosiani. Caswell was moved to Takalani following the March 2016 litigation. He was only in Takalani for a month before he died. Mangana Eric Mashilwane was the father of Zenzele Lincoln Mazibuko. He would make up stories to her, for example, that he was a millionaire. SABC Michael Clorwe was the brother of Ike and Andrew Clorwe and the father of Batsiba Clorwe. Michael died after being moved to Shama House. Josephina Mhlongo was the beloved mother of Fortunate Nkabela. Her daughter found her at Tuli home wearing a thin dress and sitting outside during winter. Franz Decker was the brother of Magdalena de Lange. His sister found him with a broken ankle at Sepong. Muhammad Adil Sharif was the nephew of Rudeba Jones. He was moved from one NGO to another before he absconded. He was 21 when he died. Isaac Tolwana was a beloved brother and a brother-in-law of Paulina Tolwana. He was moved to Shama House without his family being informed. Jean Rontwetsa was the beloved mother of Joyce. She died without her mother knowing where she had been moved to. Sedumedi Solomon Moatse was the brother of Kefalotse. When his brother visited his brother at Moseko home, he found that Sedumedi had been burnt from the waist down by hot bath water. Maria Maretele was the sister of Daniel and sister-in-law of Lydia Maretele. She was a mother of Tabang Maretele. She died after being moved to Takalani. Nellie Dutoit loved biltong. Her sister Bertha said that Nellie was a kind, gentle, and happy person. She started crying as soon as she saw her family after she was moved and was in a wheelchair for the first time. David Senecal was a father and a grandfather. When his daughter Desiree went to visit him, he loved to play with his grandson. He died after being moved to Moseko home. Frederick Nelson was a beloved brother of Abram and saw his family every week. He died after being moved to Sepong. Memona Dubry was a beloved grandchild. She died on Christmas Eve. Happy Makubela was a happy and beloved son and brother. His family did not get to see him before he died. Nswelengwe Mokheti had a very big appetite, and he loved his family. Alfred Sitole was a beloved nephew. He used to complain to his Aunt Elizabeth that he was being served rotten food at Tuli home. Sipiwe Tabete was much loved by his two sisters and enjoyed their home-cooked food. Sipiwe passed away at Precious Angels at the age of 41.
Well, thank you, Council. It's the last post of sorts. Thank you. Very important in a matter like this. Just to remind ourselves that we are dealing with human beings, and that's what they are. Thank you.
Human beings and members of a family and a family unit.
Yes. Thank you so much. And on a lighter note, I think your pronunciation is amazing. Very well done. Advocate Krause.
May it please you, Justice. We will be very brief. Firstly, the common law has changed after a few hundred years, and I misled the court yesterday when I spoke about litis contestatio and the death of a person. Can I just refer you to, I was referring to, in paragraph 148 of my heads of argument, to the matter...
You must have met a professor of procedural law who told you, well, you could have possibly been correct.
Justice, in paragraph 148 of my heads of argument, I refer to the matter of Mordechai Mfapu, whose brother died prior to the terms of reference. The law has been, by majority judgment, changed in Nkala, N-K-A-L-A, versus Harmony Gold Mining, 2016, volume 5, South African Law Reports, page 240. It's a Gauteng decision. The majority judgment is by the Honorable D.J.P. Majopela and by the Honorable Mr. Justice Vali. And they deal with the whole aspect of general damages and the effect of the death of the person that suffered from paragraph 176 and further. And their conclusion at paragraph 220 is that a plaintiff commence suing for general damages, but who has died of any cause, whose claim has not reached letus contestatio, and who, but for his death, would be entitled to proceed, his estate can proceed. I would therefore submit that in terms of the arbitration, the terms of agreement is perhaps letus contestatio, but the Ombuds report would perhaps be the start of the proceedings. I leave that aspect completely in your hands.
No.
Justice, then if I could just deal with the counselling aspect that was raised by my learned
It should
friend.
surely be the conclusion of the arbitration agreement. That's when parties join issue, isn't it?
Yes. Justice, if I could then perhaps move to paragraph 187 of my heads of argument, and this is in respect to my learned friend's suggestion that the state must provide counselling for all the members. We've presented evidence that our clients do not trust the state to provide those counselling services. In terms of the court case at page 187 of my heads of argument, unless there's a legislative empowering statutory something in the legislature empowering the state to give these counselling, which there is not, or unless we agree to it, they cannot provide counselling to us. For that reason, we've quantified the amount. As far as the other two claimants are, they've agreed to receive that counselling. Our clients have not agreed to receive counselling from the state.
But counsel, how practicable is that? And how just the magnitude of the survivors makes it quite a trying matter, isn't it?
Well,
To have private counselling of over 1,000 patients who are kept in state facilities or facilities funded by the state. How practicable is it to have them get private practitioners?
the mental health care users, with respect, Justice, they will receive counselling in their respective places where they are. This is not part of the award that the court is making. This is in respect of the family members that seek counselling outside. And it's our submission that the administration of that is much easier in respect of quantifying that, as we've done in the amount of 20,000 Rand per family, than to put another administrative burden on the state. And because of the cogent reasons that we've advanced, and because of the law being on our side, we submit that we would rather have the quantified amount in terms of future medicals, as we've asked for in our statement of claim, and we have done here. So we submit we're not part of the agreement that has been reached in respect of counselling.
And how would this work? As and where you discover more claimants who would come to the fore, later they'll do what? They'll go to the Guardian Fund and claim the 20,000. Where would the money sit? How do you deal with this interest?
Justice, on this, we ask that this be paid to the family members that are before you, the 168, the family members that are. We couldn't find anything in the terms of reference that further family members will as of right be entitled to compensation. I think the process needs to end somewhere. So we have, for the 168, quantified this amount, and that is where we are asking for it. If I could then move off from the counselling aspect, Justice, if I could just move to my learned friends.
And the award for the 168, where would it, should I direct be paid to?
Justice, and this is the next point that I want to make.
Yeah.
We have in our heads of argument distinguished between healthcare users that we've asked that their amount be paid into the Guardian Fund, and family members in respect of general damages, that amount be paid by the family member that's been identified. So we're on a different footing as the rest of the claimants, because we have survivors and family members, and we've dealt with general damages in respect of both of them. So that needs to be a distinction. In respect of general damages to mental health care users, that needs to be paid into the Guardian's Fund. In respect to family members, that needs to be dealt with on the same footing as the other claimants, and that will be paid to the families itself.
But of course, the point seems fairly plain that if you were to pay general damages to family members and pay constitutional damages to survivors, there will be a measure of double dipping, surely.
Yes, Justice, that's why our argument is general damages is not sufficient because of the breaches of the, and for that matter, we have pleaded general damages fairly substantially, but we submit that that's not sufficient. And insofar as the court found that not be sufficient, we suggest that it should be in the amount of 1 million rand. But that brings me to my learned friend's argument in respect of constitutional damages. My learned friend relied on paragraph 4.2.5 of our statement of claim. We submit that insofar as necessary, we will ask that paragraph 4.2.5, that's in respect of constitutional damages, be renumbered to paragraph 5.3. And our argument of yesterday would then stand that we ask this in respect of the mental care health user as defined in the Act. And as the court rightly pointed out, mental health care user in the Act includes the family. So in respect of the constitutional damages, we submit a split between these two entities would be necessary.
Yeah, but you're not inviting me, are you, to grant general damages in respect of family members, and then grant constitutional damages? That would be in respect of which category of claimants?
Justice, our argument is that there are general damages suffered by each of them. Unless the court found that we haven't suffered shock or psychological damage, then it will only be thrown over the bow of constitutional damages.
You see, if you go to shock and pain and suffering, then you are in a terrain of the common law, and you're obliged to go and look at awards that have been made up to now.
Yes, and that is what we've done.
As has been argued by the state, I think correctly. And then if you go to constitutional damages, new considerations kick in.
Absolutely, Justice. And for that reason, and the state has now publicly offered 200,000 rand for family members, but they've coupled that with mental health care users. But for each of the other claimants, they've accepted general damages for the family members in the amount of 200,000 rand. We say in our submission, general damages should be higher for family members and much higher for mental health care users, but that in itself, bearing in mind the constitutional damages that, or breaches that took place, that amount is not sufficient to cover them. So the only submission that we're making to you at this stage is to say there are two categories that we are representing.
Yes, notionally there always are. I'm saying in substance, if mental health care user A, Thabo, and his family to Thabo, if you were to contemplate awarding 1 million to Thabo and 1 million to the family, firstly, you are out of sync with what you might award to the rest of the participants in this horrible tale.
I take your
And secondly, those families would actually, there's a phrase about this in Zulu, bazokuhlafuna ngemhlathi emibini.
Justice, I would need an interpretation.
Yes, we need interpretation, and one of your colleagues might help you. It means they'll be chewing with both their jaws. In that language, when somebody has a lot of food, they're obliged to chew with both their jaws. That's how much food they have. So I'm just saying, you must acknowledge that there'll be double dipping. If you invite me to give $1 million to the families and $1 million to the patients.
In respect of constitutional damages, Justice, is that what the question is?
If you do both. I mean, if you were to award, as and when you consider constitutional damages, inevitably the considerations on general damages would also arise.
Yes.
So you can't give to both as if you have not awarded anything for general damages.
Now, absolutely, Justice, and we're not suggesting double dipping, but what we're saying is that the constitutional breach, in addition to the general damages, should amount to R1 million, and that amount needs to be split between the family and the mental health care user.
I hear you.
Then, Justice, we've dealt now with our reply, but might I just be allowed to thank you and the staff and the translators and civil society for their role in everything that has happened in the past 40-something days. Thank you, Justice.
Thank you so much. We'll find time to thank all of you in a moment, but thank you for the kind words. Advocate Groenewald.
Thank you, Justice. Justice, we have no reply. I think my colleagues have dealt with all of the issues. From my side, we'd also like to thank yourself, Justice, and the support staff, the family members for all the kind words of support each day. And I've just been reminded by Oba King that we request the family members to sign the banner there at the back and show their participation in this process. But once again, thank you for everybody that supported us in this process.
That's wonderful, but keep that in mind. The day you form a political party, make sure the name starts with an A.
Thank you, Justice. I hope it's not prophetic words from you that I end up one day in Parliament, but yeah, thank you.
Thank you, Advocate Groenewald, and thanks for the kind words. Counsel?
Justice, with your indulgence, I beg leave to hand up 2 documents which we undertook to hand up. The report by the Ombud, which dealt with the list of the 12, which is LR 172, and then the pledge is marked LR 173.
Thank you.
And then, Justice, through my engagement with you, like I beg leave to give reference to an authority which I've omitted to make mention of.
Which is not in your heads.
Which is not in the heads, Justice.
Yes.
It is the case of Duplessis versus Road Accident Fund.
Yes. 2004,
Volume 1, SA 359, a decision of the SCA. And particular reference is made to paragraph 35, which deals with the powers of the court relating to the development of common law. And Justice, on the last occasion, you mentioned that it has come to your attention that there is an account, a Twitter account opened in your name, and which was, in fact, not true. Justice, I'm informed that a fallen victim I'm told that like there is a Twitter account circulating in the social media in my name with my picture. I want to put it on record that I don't have a Twitter account.
Is the picture real?
And I don't even read tweets.
Yes. Thank you, Counsel. You're worse off than President Trump, who tweets every morning. But I take the point. Yes, we are in a world of zillion media people, and they express themselves about all of us. I do read but I don't tweet myself. So yes, there's a lot said about all of us in there, and lots of pictures of all of us in social media. We have come to, let me allow the evidence leaders to say something at this stage before we close.
Thank you, Justice Msaneke. I don't have much to say except to thank our colleagues for the assistance and support and encouragement and giving us space that is to perform our duties, especially the officials from the Department of Health, in particular Dr. Kinoshi. Every time we needed assistance from his staff, support staff, he will be the first person to jump, be it at early in the morning or at night. He was always ready and available to assist. We have been able to get hold of many witnesses and to consult with them through his assistants and the other support staff. And the Director General as well from the Premier's office, she has been very of assistance to us.
That's Advocate Baleni.
Advocate Baleni. They have all played their roles in order to ensure that the arbitration proceeds without any hindrance. And Bafana Malunga as well, who has been with us throughout, he has been there, also supporting us. And I can't mention all of them now. And your presence, justice and leadership, guidance, we have learned a lot through your, that is through your guidance. We thank you for the opportunity, and my colleague, Ms. Yina, would say a few words as well if she has anything else. Thank you, Justice Msaneke. We can't thank you more than this. I think there are no words which can express what this opportunity has given to us. Thank you.
Thank you, Justice, and thank you for the opportunity. And I would also like to thank our colleagues for the collegiality and the professionalism and the manner in which you have handled the matter up to this far. And also in a special way to your support staff, Obakenge and Aviwe. They've been very helpful, and they've been prompt in responding to our requests and to our communications. And thank you for the opportunity.
Yes, Nkosi Council. We've come to the end, believe it or not. We have come to the end of quite a trying task. For those of you who are not judges, it happens often. After all the excitement of proceedings and the challenges, there comes a time when a judge retreats to deliberate, to consider. Arguably, that may be the most difficult time. It's a lonely time again, because you retreat again into your tower and hope to produce a just and equitable outcome. It's always amazingly challenging to those who think it is glamorous and fun. And we've come to that point where I have to do what judges routinely do, is to go back and agonize and get it right and hope to produce just outcomes. That's what's going to happen now. This was an arbitration. Much confusion out there. People call it an inquiry, call it a commission, and I think it mainly because of the total circumstances. But just to recap, I think also for public recordal and interest, this was an arbitration. It was a subset of an alternative dispute resolution called arbitration, chosen by the parties. in which they submit ultimately to an award by an arbitrator, which, if not reviewed and set aside, would be binding on all the parties. And therefore, they'll be obliged to implement the award, which ranks same status in our law as a court order. So we've come to that point where I have to go back and weigh all of the submissions and the evidence and write out what are the grounds. First, the decision in its full flurry and detail, and what are the grounds for reaching those findings. We have agreed that the award will be available within 30 days from today. So we have to go out and work very hard to try and keep that timeline of an order, an award in 30 days from today. And I'll be privileged to go back and do that. And my thanks start there. I want to thank the family members to start with. But for their pressing and probing, we wouldn't have been here. So kia leboga ndiyabulela, kiyabonga, nitirile. But for your insistence, and civil society should keep doing that, justice is elusive. It's hard to get at. So it was really wonderful, and the recordal that we have of your role will be seen by posterity over many, many years as researchers come to look at this record. And all the support you've had, certainly from Section 27 and other attorneys who later came on in council. I'll talk about them in a moment. And I'd like to thank the state. It's not often said, but it's true, the state played a very vital role. In fact, an exemplary role in many ways. I don't say everybody who testified for the state was amazing. I'm saying the state took its responsibility to implement recommendation 17 to find an arbitrator. And I know they made representations, many, to me. And I initially said no. And the family started pushing also, and ultimately agreed. But so the state must not be left out of it. It will be an error, because it's a good model, an example of how to get at a deep atrocity and to try and remedy its consequences and root it out. So I'm very grateful to the way, and the state provided resources to this process in a real generous way, supported the families to be here in a variety of other ways. So very, very well done. And responsive and contrite state behaves the way we have seen happen here. I want to record that quite publicly and openly. And then I want to move on to all the people who have been active here. Thank you ever so much. Starting with the council, I went looking for the 2 young people who have employed in the arbitrator's office. Ubakeng and Aviwe. You are very special, hardworking, young law clerks who came in and started with the task, and they have not disappointed. But the work is ahead. The next month, we have to produce an award and have it all edited and sign-checked, and the things you used to do in the Constitutional Court. We're going to have to do them here and get that task behind us. But you've been very, very special and amazing, way beyond my expectations. And the evidence leaders, who right at the beginning you agreed to be here, and I'm glad you found it worth your while. And I hope it adds on to your careers. And thereafter came a variety of counsel. Very early, Advocate Groenewald was in the mix. And with the same booming voice, he was insisting that his clients should be protected. And he got it right. He worked his way into to the table and found a space on the table. And I'd like to thank you. It's not easy to do good, particularly when you're young. But it has been wonderful for you to be here. Advocate Krause, and your entire team. It was wonderful to have you here. And again, the Law Society of South Africa is at the right place, the progressive end of our world. It's very important to take positions that advance goodness, particularly when public power is misspent, misused. It is so important to see the Law Society, a state entity, taking its rightful role and protecting the vulnerable. Legal aid, what did I say? Law Society, my goodness. Yeah, Legal Aid South Africa, LS. Yeah, I think that's what confuses me. But I'd like to thank you ever so much for having been part of all this. And I'd like to thank Section 27, Advocate Hassan, together with your Leonard colleagues and your Leonard Jr. It has been wonderful to have you here. And you know, it cannot be done without actually a collective work of all of the council, all of the attorneys, all of the researchers. A lot of hard work gets produced by many people, but look where we are. We've managed to get over all this. I want to spend a little bit of time to thank the media, and I've done that over and over again. Social consciousness is derived from information that the public at large has. But we've had over 11 cameras or so in here for every time we sat. And we've seen most of your crossovers throughout the day and in the evenings and the wrap-ups. And all of the presenters here who have shown amazing interest in something that I hope will be a contribution, a tutorial on good governance, good citizenship, and how to be good South Africans. So the media has been amazing and have shown, I meet people all the time, anyway. Again, you might need interpreters there. But it happens just so often wherever I step out, people say, hey, we saw you at Esidimeni. And they say, because I think, and people of all extractions in South Africa have been watching, and only because the media has been available. For the security, there have been tight moments. I'd like to thank all of you. There are very dangerous moments here. But very quietly, the security has been managed. And our interpreters. They've been amazing, and you know, they have, and again, the state made it possible and provided the resources to have full wall-to-wall interpretation, which most of us take for granted. And I really would like to thank all of you, and many other people who are not necessarily family members who have come here, except for those who wanted me to sign the book all the time. They knew where to find me, but beyond that, there are many people who have come and taken interest. We've always had a full house from day one. I am most grateful. And may God bless our country, and may God bless Africa. Thank you. We are adjourned. Thank you. Oh. Should I start? Yes. Am I entitled to start? Shouldn't the family start? Nkosi, thank you.
Sorry. What to say?
Thank you. Okay, then.